What happens in a democracy when citizens who can't afford lawyers to defend them end up in front of the courts, sometimes for very serious charges? In some cases, people are spending up to 3 years in jail and then being found not guilty, which is just mind-boggling, really, and rather cruel. ABC Central Coast Meghna Bali has found there's a looming crisis for the legal system. She's speaking here with Central Coast-based Manny Conditsis, senior trial advocate and accredited specialist in criminal law, in regards to what's happening in legal aid at the moment with the payment of advocates.
Legal aid rates, as a very rough rule of thumb, probably pay somewhere in the order of about 25% of what a senior trial advocate or senior barrister, if they had a private paying client. Most people in the legal profession who have been around a while are happy to help out, and a lot of people do even pro bono work, let alone legal aid, but you can only do so much of it at the end of the day. The rates are very poor, but as I say, by and large, most members of the profession try to help out where they can. What's relevant to this discussion, I think, are two things, maybe three. One, in Australia, there is no fundamental right to legal representation. In other countries, there is that right. We don't have it in Australia. However, there is a fundamental right to a fair trial. And the High Court has agreed that cases, criminal cases particularly, may be temporarily stopped until the accused person has legal representation for the upcoming trial.
The way that this particular case is manifesting is by the time that the accused has legal representation, they would have been in prison for 3.5 years. Now that represents obvious detriments to the accused, especially if we go by the principle that you're innocent until proven guilty. There's obvious consequences for the accused there, aren't there?
Absolutely, and you've hit the nail on the head. The longer a person is in custody awaiting a trial, then the greater the prejudice to that person, bearing in mind the very important principle of the presumption of innocence, which quite commonly today is said, but it just rolls off the tongue as if without any meaning almost. But bring it back to its basics. A person is innocent. Pause, reflect, innocent, yet that person remains in custody in prison until he or she has her trial. Through no fault of her own, if the person is impecunious, doesn't have the funds to fund a trial, for whatever reason legal aid won't fund it, then that person would have to represent himself or herself. If legal aid is paying, as a rough rule of thumb, 25% of the rates for which a senior criminal lawyer would be entitled, that's one thing. But the next problem is that a lawyer may spend 20 hours on a matter and only be paid 4 or 5 or 6 or 7 hours, whatever it may be, a proportion of the amount of time that they would need to properly prepare the matter.
Do you stand behind the Private Bar Association essentially saying we need to have a united front in rejecting these sorts of cases until the New South Wales government does more to raise rates?
Absolutely. At the end of the day, if something drastic isn't done, nothing will happen. It's all very well for politicians to be espousing that the legal aid budget has increased by XY%, usually a fairly low percentage, maybe significant in the overall purse, but a fairly low percentage increase. But what base are they working from? And the base is very, very low.
What would you consider a reasonable increase of these costs be?
Obviously, it would depend on the seniority of the person that would be taking the matter on.
Say we whittled it down to something like this high-profile case right now, where you've got a murder charge. What would you say?
Well, I would have thought a reasonable increase would be something in the order of paying the practitioners involved there or thereabouts to at least half of their rate, but not a quarter. And I appreciate that based on current levels of funding, that would probably mean that in that case they'd have to double what they are currently paying.
This is one example of a trial that's been delayed by 6 months. If no drastic action is taken right now, what's the impact going to be on the wider criminal justice system in this state?
Well, the more matters that are stayed and held in the system, the more pressure that is going to put on the busiest trial court in New South Wales, and as I understand it in other states and territories as well, and that's the district court, the trial courts. Due to changes in legislation in New South Wales over the last 12 months or so, a bit longer than that, my view and the view of many criminal law practitioners is that due to the changes in legislation, in procedure of indictable matters, that many more matters are going to find their way up to the district court, and consequentially there will be inevitably, over a period of time, a backlog of those matters unless the state government continues to employ more and more judges to deal with the load. In Western society, anyone that is in prison for 2 years or more without trial can be seen as fundamentally unfair and a fundamental injustice.